that is Limited Liability Partnership Act, and the topic which we were discussing in the last class, so that we can continue later when we'll have the presentation and all. So, friends, we are starting with the new act which is called as Limited Liability Partnership Act, and in the earlier classes also you must have make yourself familiar with the concept. So when we talk about Limited Liability Partnership Act, so we have to understand from the legal perspective that if a particular organization exists as a limited liability, so how it can come into existence, what will be the legal norms which will apply on this, what will be the legal requirements with respect to the parties, composition, registration, winding up and conversion of LLP. So it's a very simple act. Not much technicalities are there, but we just have to make ourselves familiar that why this particular form exists, how it can be beneficial, and what are the legal requirements which needs to be fulfilled for the formation of LLP. So the particular act is known as Limited Liability Partnership Act 2008. So earlier, if we talk about the Indian Partnership Act 1932, there we are aware of, if we talk about the features of the particular partnership act, so we say that the partners join hand together to run a business organization with a profit motive. And when we talk about the profit motive, so we say that the partner can be a working partner, there can be the partnership agreement which is known as partnership deed, and they can decide about how to work in the partnership firm, what will be their P&L ratio, etc., etc. The basic feature, or we talk about that how the LLP differs, that is that here we use the term limited liability. And if we talk about the partnership act, partnership firm, as per that act, so there is unlimited liability. That is, the partner's assets, personal belongings can be attached for the liability which they have, incurred while running the partnership firm. So that was the major drawback, or we can say that limitation which the people suffered, or it has been perceived that some better option needs to be there. And if we talk about the forms of business organization, all of us are aware of that there is the sole proprietorship, then there is partnership firm, there is a private company, cooperative society, public company, or body corporate as such. And this LLP, limited liability partnership, is the new form of organization wherein it is a combination of the partnership firm as well as a body corporate. So if we talk about a body corporate or a company, so that particular company has a separate legal existence as per the law. And if we talk about separate legal existence, so it means that this particular company in the eyes of law is considered as the much better organization. As a business firm, it exists separately, and it has several other features which makes it unique and a proper organized and professionally run organization. So here in what will be the objectives, how the particular corporate will be run, and how the participation of the different parties will be there in respect of the management and all. So everything is governed by the law, and as per the law, the particular organization exists. So if we talk about the LLP, so LLP is the hybrid model, or we can say the combination wherein the all the good points of a partnership firm and all the good points of a body corporate have been merged together. So as per this particular form, it has the flexibility option of operations and designing the particular rules and regulation as per the partnership act, and to run it professionally, it can pick the things or the good points from the body corporate. So LLP is considered as a new corporate form which have the alternative as compared to the traditional partnership, which have all the good points of traditional partnership and the good points of the body corporate. So if we compare, so unlimited personal liability is gone, and the governance structure is the another important part which is taken into account. So nowadays, if the people are taking new skill based businesses or entrepreneurial initiatives, so there is LLP is considered as a good option as a business form of organization. So as per law, we say that it is the alternate corporate business vertical which provides benefits of limited liability as well as flexibility of organizing their internal structure. So here the we can say the best of both the organization form is combined into this. And if we talk about the applicability of the particular law, so that particular law was applicable uh, from 1st April 2009, and the rules were applicable from 1st April 2009. So if we talk about the sections, so there are 81 section and 4 schedules which we'll discuss later on. So if we talk about the utility or the benefits of adoption of this form of organization, so this is adopted for the organization which have the small enterprises and there are more investment is required. So venture capitalists can be taken as the one of the form of the investment. So if we talk about the body corporate, so there we know that the capital is divided into smaller units of smaller denomination, which are called as the shares, and shares can be offered to general public and in case of private company to selective number of partners as well. But in case of the partnership firm, sole proprietorship firm, the liability, or if we talk about the capital investment requirement, generally remains less. So here if we talk about the LLP, so there can be the small enterprise and investment by the venture capitalists can be taken. If we talk about the 4 schedules of the LLP, so schedule 1 talks about the mutual rights and duties of partners. As we say that if the in case of partnership firm, the terms and conditions are not decided, then the table A will give us the rights and liabilities and the situation. And if we talk about the body corporate, then again there are certain rules which are given. If the article of association is silent about certain things, then the reference can be taken from law. So similarly, if we talk about the LLP, Limited Liability Partnership Act, so if the partners remain silent or the partnership LLP agreement remains silent on certain points, then in that scenario, the Schedule 1 of LLP Act will be applicable, which talks about the mutual rights and duties of the partners. Similarly, when we'll move further, we'll see the conversion rules. So that the conversion rule from one form of organization to another form of organization will be discussed in Schedule 2, 3, and 4 respectively. Now, if we talk about the rules, so simple old partnership act had the unlimited liability, and the LLP new act have the new rules. So we have to go according to this. Generally, a question is being asked with respect to the features, characteristics, or we can say that the what do we understand by the limited liability partnership. So in this particular case, the very first feature is the limited liability of the partners. Limited liability of the partner means that whatever they have invested in the organization up to the amount of investment is their liability. Their personal assets or personal belongings cannot be attached for the same. Then another feature of the LLP is body corporate with perpetual succession. It means that when we talk about the existence of this particular organization exists within the provisions of the law. So the winding up will take place within the provisions of the law. So till the time there is the winding up takes place, from its existence till winding up, it continue to exist. There may be possibility that if we talk about the partnership firm, so if all the partner retires or all the partner dies except one, the firm will dissolve automatically. But in this particular case, the firm limited liability partnership will continue to exist for long. There is going to be the perpetual succession of the particular organization. Then If we talk about the number of partners, so LLP can be started with minimum 2 partners, and there is no limit in on the maximum number. If we talk about the partnership firm, so in case of banking business, there is a limit of 10 and 20 in the other business respectively. So there is a maximum limit. And if we talk about the private company, the maximum members can be 50. But if we talk about LLP, so there is no ceiling on the maximum number of the partner. Then we have the simple registration formality. If we talk about the existence of a body corporate, though nowadays we have the online facility, online registration of the company, and the process has become much simpler as compared to the earlier days. But still, we say that the existence of a body corporate or registration of body corporate requires more formalities and a little lengthy procedure. But in case of LLP, it requires a very simple process and there are less registration formalities for that. Then we talk about that the if we talk about the how the partners are going to work, what will be the requirement. So all these things will be recorded in the LLP agreement. About the LLP agreement, we'll discuss in detail how it is being scheduled, or what are the features, or what points should be there in the LLP agreement. So in case of registering the limited liability partnership, a detailed agreement is not mandatory. So if detailed agreement is not there, so in that particular case, schedule 1 will talk about the all the provisions will apply in case the detailed agreement between the partners have not been made. Then there is another beautiful feature of LLP is that partners can bind only LLP, not other partner. If you remember the Partnership Act, there was a rule of mutual agency. When we talk about mutual agency, so it means that partner act of a partner binds the other partners and as well as the firm. But in case of LLP, a partner can bind the firm only, it cannot bind the other partner. So the rule of mutual agency does not exist in case of LLP. So that is very important. So in case a person is entering into a contract, so if he incurs any kind of personal unlimited liability, so it cannot bind the other partners. In this case, the only the firm will be, or the assets will of the firm will be bound by that. So it says that this is an important feature of the LLP organization. Then there are another characteristics that is already discussed, that LLP is having separate legal entity as a body corporate itself, and also have the perpetual succession. Any change in the composition of the partners shall not affect the existence, rights, or liability of the LLP, because LLP is existing as a separate entity. So when it exists as a separate entity, so if the partners are leaving, their composition is changing, some are retiring, some are joining, but it will not affect the existence of the organization at all. Then LLP, as it exists as a separate legal organization, it can purchase assets in its own name, it can enter into contract in its own name, it can be sued or it can sue the other party, it can acquire, own, hold, or dispose of property, etc. And the signatures of the LLP will be with the common seal, which we generally call as a stamp of the organization. So in this similar way, the way body corporate does in their case with respect to entering into the contract and identifying the transaction, similarly LLP is going to have the common seal and is going to use that. Similarly, if we say that unless specifically provided, provisions of Indian Partnership Act shall not apply in LLP. So kahin pe, if we talk about the accounts or rates of taxation, it will have the common rate. Other than that, except one or two places, no rule of Indian Partnership Act is applicable in case of LLP. Then if we talk about the existence of the LLP, so definitely we require the 2 partners. but there is also one requirement where the partners are known as the designated partners. So who are designated partners, how they come into contract, what are their roles and responsibility. A short note, a separate question can come on the designated partners as well. So let me take a pause here, and any question up till now what we have discussed? Yes, any question? No question?
No, ma'am. No,
Okay,
ma'am.
okay. I know it's a quite simple topic. Okay, so when we talk about the specifically in detail the features of LLP, so the first features are that it exists as a enjoy the status of a body corporate, having a separate legal entity and artificial person. When we talk about artificial person, so we say artificial judicial person. It means that a person or the entity which has come into existence by provisions of law. Definitely not as a natural human being, but with the help of the provision of law, it has also got a separate identity, right? This exists as a separate. So if we say that a particular organization is registered as ABC LLP, so in that case, this ABC LLP have the separate legal existence in the eyes of law. So it will exist as a body corporate, a legal entity, as a artificial person. So it's more akin to a company, means more like a company. It's not exactly a company, because company require more registration formalities or more rigid procedures and restrictions as per the Companies Act 2013. But in case of LLP, the company earlier the Companies Act 1956 was there, and the revised act is 2013, which requires certain provisions of corporate governance as well. So corporate governance is one of my favorite topic, and I have even completed my doctorate in this particular stream only. So we talk about the LLP. So LLP is like a company. It's not a company, but it is like a company. About separate legal entity, we have already discussed. So in this case, the we can say the position of the LLP is that it has the capacity to enter into contract like a private individual, but definitely not related to the act of the personal nature, say marrying and doing the promise to go out or something like that. It cannot happen. So other than the personal nature task, it can enter into contract as a private individual itself. It can have the shares investment in another company. It can be LLP can be partner in another LLP. It can be partner in the partnership act. It can have the take the loan from the bank, buy the property in its own name. So it has the separate legal entity wherein, as per its distinct name, which are different from its partner, can have the rights and liability of those of its partners, and same capacity can enter into the contract. When we talk about the number of partners, so minimum two, maximum no limit. So here one clause is there that if we talk about that if there is minimum two are required, so if there remains only one partner, the partner LLP will not dissolve. But if this one partner is carrying out the business for more than 6 months, then in that particular scenario, the one partner beyond this 6 months period will be held personally liable. This is the for the personal liability, we can say the exception, and the situation where the this general rule of that there is no limited liability, so that rule is does not apply in this case. So if at any time there are more less than two and business continues more than 6 months, then the partner running the business with this knowledge that there is no other party they shall be personally liable for the LLP, or for the obligations of the LLP during that period. That because he is alone running the business. So as per the law, as per the LLP Act 2008, this particular rule you need to remember. Then there comes the requirement of designated partners. So as we talk about the company, so in company we initially have the promoters, then we have the directors which are to be nominated, and which run the manage the business on the behalf of the shareholders. If it's a public company, then we in between we have the managing director, chairman, and the supervisory board, etc. So certain designations are there. So they people have the different responsibilities and roles in managing the organization. So when a company is being registered, the company is being registered with the as per the act, and it is registered with the registrar of the particular state where the registered office is placed. So company is the artificial person, right? And as a artificial person, if it enters into the contract, the stamp is to be there. Some person needs to represent before law, right? So this responsibility is being given to the director, managing director, chairman, supervisory board on the different ways. But when we talk about the LLP, so out of all the partners, minimum two partners should be designated partner. Designated partner means कि सब partners में से कौन से partner हैं, those who will be held responsible to meet for meeting all the legal requirements, because LLP cannot sign itself. So someone is required to present before the law. And even when we get LLP registered, it is also registered with the registrar of the Companies Act of the same state where the particular registered office is there, the particular LLP is registered. So in that case, the designated partners are those partners who are responsible for meeting all the legal requirements and submission of documents, etc. So out of all the we can say partners, two individuals should be designated partner. So out of the all partners, two partners needs to be the designated partners. And who is going to be the designated partner? जो दो इंडिविजुअल रेजिडेंट इन इंडिया होंगे. अगर वो रेजिडेंट इन इंडिया नहीं है तो वो डेजिग्नेटेड पार्टनर नहीं बन सकते. And when we talk about the resident, so it meaning of resident is understood as per the terms of Income Tax Act provisions, wherein a person who is residing in India for some specific period and satisfying certain condition is known as resident. So in this particular situation, we say that two individual out of which minimum one individual should be resident in India, and if body corporate are two are partners, then at least two individuals of such LLP or nominees of such bodies corporate should be considered as the designated partner. So designated partner should be there, and one partner should be resident in India if they are individual. Give me a second. Okay. right? So when we talk about the designated partner, they are also required to obtain DPIN number. DPIN number is designated partner identification number. If we talk about the companies, so in case of company, we require director identification number. Then about the DPIN, we can, I think, discuss later on. Limited liability, we have already discussed that the particular, in case of LLP, partner is not personally liable directly or indirectly for any obligation except जहां पे हमने डिस्कस किया था कि एक सिंगल पार्टनर जो है 6 मंथ से ज्यादा बिजनेस को रन कर रहा है. Other than that, there is no personal liability, so there is limited liability only. And liability of the LLP and partner is unlimited for all or any of the debts or other liabilities they have acted with the intent to defraud the creditor. So पहली एक्सेप्शन आपकी ये हो गई. दूसरी एक्सेप्शन आपकी हो गई कि जहां पर आपने किसी को डिफ्रॉड करने के लिए एज एन ऑर्गेनाइजेशन काम किया तो वहां पे एलएलपी की और पार्टनर की अनलिमिटेड आ जाएगी. प्लस अगर एक सिंगल पार्टनर जो है आपका wrongfully एक्ट करता है, in that particular situation, for his wrongful act, he will be having the unlimited liability. So in all the circumstances, there are limited liability, but there are these three exceptions which you need to remember, right? Then we talk about incorporation of LLP. Before, I think, incorporation and registration, I would just like to discuss the difference between the, this will take up later on. I would like to discuss this difference between a company, a partnership firm, and LLP. So when we differentiate the three form of organization on the basis of registration formality, so a company is to be registered with the ROC after following the complete formality, and certificate of incorporation is given as a evidence for the existence of the company. But when we talk about the partnership, existence of the partnership firm, it is registration is not compulsory, though we know that because of the benefits we firm registered. But in case of LLP, again, it is the compulsory registration is required with the registrar of companies itself. If we talk about the name of a company, so if it is a public company, it will use the word limited. If it is a private company, it will use the word private limited. With respect to the partnership, no guidelines are there. And in case of LLP, it is required to use LLP or limited liability partnership with its name. If we talk about the capital contribution, so capital contribution in the companies can be 1 lakh or 5 lakh respectively. In case of partnership and NLP, no, it is not required. If we talk about the legal entity status, company has, there is no in case of partnership, and there is a separate legal entity in case of LLP as well. One second. Okay, so if we talk about the liability, so in case of a company, there is going to be the unpaid capital. So the unpaid capital is one which is there. sorry. In case of if we talk about the company, so whenever we talk about the shares, so if a person is buying the share, then his liability is limited up to the unpaid value, right? Even in you must be studying in the accounts, issue of shares, forfeiture and all. So the liability remains with respect to the unpaid amount only. But in case of partnership, there is going to be the unlimited liability. But in case of LLP, there is going to be the limited liability with the three exceptions which we have discussed. If we talk about the number of shareholders or partners, minimum 2, maximum 50 in case of a private company. In case of partnership firm, minimum 2, maximum 20 and 10 in, I think, banking business. And in case of LLP, minimum 2 and maximum no limit. So these are going to be the unique features of this particular form of organization. Now, when we talk about the foreign nationals, so in a company, foreign people, there are foreign institutional investors, foreign direct investment is there. So there is possibility. In case of partnership firm, it is not allowed, but in case of LLP, foreign nationals can be the shareholders. Then if we talk about the meeting requirements, so in case of companies, regular meetings are there, but no foundation with respect to the partnership and the LLP as well. In case of, we say, filing of the annual returns, etc., so annual returns are required to be filed with the ROC, and also in case of LLP. But in case of partnership firm, there is no mandatory requirement as such. With respect to the audit, it is compulsory. It is compulsory, and it is required if the particular contribution is more than a particular limit. Now we talk about the how the bankers or outsiders or any investors, or we use the word stakeholders, view a particular organization. So as a company is having the registered legal norms, so high credit worthiness is there. But in case of the partnership firm, it would depend upon the goodwill, that how the people are working, since how long they are into business, how honest they are, how whether they have grown the business or not. But in case of, again, LLP, it has as compared to the partnership firm, have more credibility in the market, but lesser as compared to the company. But it is, we say that the hybrid model or mid model, where the plus point of partnership firm and plus point of a body corporate are both exist. When we talk about the dissolution procedure, so in case of a company, it is a lengthy procedure, and it is less procedure as compared to the company. So again, there is a plus point. But in case of a partnership firm, if there is insolvency of the partner, or by the court order or by the mutual agreement by the partner, they can dissolve. So it is easy to dissolve. And if we talk about the whistleblowing provision, so whistleblowing provision is there in the case of the companies. Now, whistleblowing provision is there. In case of partnership firm, there is not such provision. And in case of the LLP, whistleblowing provision also exists. If we talk about the taxability, so it remains, keep on changes as per year to year basis. In case of partnership firm and in case of LLP, it is 30%, and as per the surcharge and all is going to be there. So my again, one more area of specialization is income tax laws, that is called as the direct taxation. So it is also one of my specialization area. So probably if at all allowed, so we'll get the opportunity to teach you this paper in the next semester. So I think if we talk about the questions of this particular section, would like to tell you that these topics can be covered in this first section or the first unit. So if we talk about the LLP Act, so within LLP Act, the first topic is about the introduction of LLP. So there can be the small or the lengthy question which talks about the what do you understand by the LLP itself? What are the major legal provisions of LLP? What are the salient features of the particular organization? And for which kind of organization it is considered to be appropriate, and why a person should opt LLP over a partnership firm or a company. So as such, it will give you the difference between a company, a partnership firm, and LLP. So these can be the possible question, and in later sections we are going to discuss about the what do you understand by the LLP agreement, how it is formed, what are the features. Then there is a separate question with respect to the designated partners, meanings, requirements, their duties, authorities, etc. Then there is with respect to the LLP, there are the with respect to, we can say that the rights, liabilities, or position of the organization. Then there is the accounts and other legal requirements. Then we are going to discuss about the conversion of different forms into LLP. What will be the legal procedures and requirement? And here we'll discuss about the schedule 2, 3, and 4 respectively. And finally, the dissolution of LLP. So from this particular section, you are going to get a complete question for 15 marks with internal choice. So this can be again 5, 5, 3 questions, 7 or 8 or 9 to 6, 2 question, or 10 and 5, 1 question. So there are going to be 15-mark question out of this particular section. So we'll have to discuss. So we'll be covering the LLP agreement and the other topics in the next section. So now, if you people have any query, if you want, we just can go through the previous slides, and you can see that if you have any query with respect to any of the item, but we'll be surely discussing all the things in detail. So if you do not have any questions, so we can take up the incorporation procedure of LLP, incorporation and registration. Yes, please. Do you have any questions?
मैम एक बार डिफरेंस में वो विसल ब्लोइंग वाला पॉइंट समझा दो.
Okay. When we talk about the whistleblowing, we are going to discuss this topic in detail. Whistleblowing basically means that when something is going on not correctly in the organization. So in that case, if one of the partner raise the particular issue or inform the higher authorities with respect to that wrongdoing, because of which the organization may suffer some loss, then a particular partner or the particular person is being given the protection from for protecting his interest, or something wrong is not to be done with him. So this whistleblowing provision basically has come from the concept of that if a person is working in the company or in LLP or in the organization, and some thing or wrong or against the interest of any of the party is being happening, which is unethical or which is not good for the organization, or which may harm someone, and and you raise the alarm, you blow the whistle with respect to that this particular thing is going wrong. So the person who is blowing the whistle, who is raising the alarm, is known as whistleblower. And whistleblower interests are protected by law in the form of that he is doing good, his intentions are good in raising the concerns, so in that case his interests are protected. This particular provision is known as whistleblowing provision, right? So in this case, High Court or tribunal may reduce or waive any penalty which is leviable against any partner or employee of LLP if such person has provided useful information during investigation. So this is the concept known as the whistleblower provision. Yes, right?
Yes, thank you, ma'am.
Any other point? So,
Ma'am,
yes, please go
ma'am,
ahead.
ma'am, can you
No,
explain
ma'am.
designated partner?
Yes, Viche?
Ma'am, the designated partner.
Designated partner is that partner who is being given the responsibility of doing all the legal transaction or representing the organization before the registrar office. Doing, we'll discuss the rights and duties of the designated partner. So if there are, say, no limit of the partner, but someone needs to represent the partner organization in front of the legal requirement, or signing the papers, maintaining the accounts, or giving all the information, right? So these partner who are being authorized to do so are known as designated partner. So अभी जब हम incorporation procedure सीखेंगे, so we'll come to know कि the designated partner need to give his consent to act as the designated partner. So अगर if there are 100 partners, so 100 में से minimum 2 partners should be the designated partner who is going to take up the responsibility in all legal proceedings. So we'll be discussing, a separate chapter is there on the designated partners.
Yes, yes, ma'am.
Right? Any other question?
No.
Okay, so I think we can discuss the incorporation and other things in next class.